tonight's presentation, the end of supervised maintenance. And neat picture there, that's an EAA Weeks hangar just several weeks ago. Mike Patey actually donated his Lancer that he had built, where he installed a turboprop on that thing. I don't know how ungodly fast that airplane went, but I guess it was pretty fast. Anyways, Mike donated that to EAA, and they had just taken it off the semi. They're putting it together in we call it the Weeks hangar here at Whitman Airport, where EAA keeps all its flying airplanes. You see the B-25. You can even see the wing of the B-17 back there, the Travel Air. So cool airplanes. So
I think that Lancer will hover in ground effect.
Yeah, right. Tonight's presentation is being given by Mike Bush. Mike is president of Savvy Aviation Incorporated, and he's an author for all kinds of stuff, publications and podcasts and webinars, and prolific sharer of information. And Mike has a CFI certificate, A&P certificate with IA, 2008 FAA's Aviation Maintenance Tech of the Year. Mike, thanks a lot for starting out the new year with us with this great webinar. I'm going to turn control of the presentation over to you.
Okay, well, good evening, Tim. Happy New Year to everybody. 2025 is going to be a fantastic year. I started it off. I decided I really needed to go flying over Christmas week, so I got my 310 here in California, and I flew it all the way to South Florida and back. Nice little cross country, and it was a fabulous week, and I got to stop and see lots of friends everywhere. So this is definitely going to be a good year if it starts out that way. Anyway, the subject tonight, the end of supervised maintenance, which hopefully isn't going to happen, but it's a really interesting story, and it really starts out with a regulatory question, which is who is allowed to perform maintenance on a certificated aircraft. You know, on an experimental aircraft, pretty much anybody's allowed to perform maintenance, but there are pretty strict rules about who can work on certificated aircraft. And there's a reg for that. The reg is 14 CFR 43.3. And it's a pretty long regulation. The title of it is Persons Authorized to Perform Maintenance, Preventive Maintenance, Rebuilding, and Alterations. And it's part of Part 43, so it applies to certificated aircraft. And it's a long rule, and it has a whole bunch of subparagraphs that talk about all of the various people and organizations and stuff that are allowed to perform maintenance on certificated aircraft. And it has paragraphs for all the usual suspects. A&P mechanics are allowed to do maintenance on certificated aircraft. Part 145 repair stations. People holding repairman certificates who are working under a Part 145 repair station are allowed to do maintenance. Part 121 air carriers can do maintenance on their aircraft. Part 135 charter operators can do maintenance. And under certain limited circumstances, aircraft manufacturers can perform certain maintenance operations like inspections and alterations on aircraft that they manufacture. Now, on top of this list of usual suspects, there are a couple of other paragraphs in this reg that are particularly interesting. One is a paragraph that says that, and we've talked about this in past webinars, that pilot-rated aircraft owners are allowed to perform preventive maintenance on aircraft that they own and operate under Part 91. The aircraft have to be operated in non-commercial service, and the owner, a pilot-rated owner, is allowed to perform preventive maintenance on the aircraft that they own and operate. It used to be that preventive maintenance was defined as a list of 31 specific items that are enumerated in Part 43, Appendix A. And then in, I think it was 2009, there was a legal interpretation that came out called the Khalil decision, or a Khalil interpretation, that indicated that that list was exemplary, not exhaustive, that there were lots of other things that the FAA would consider to be preventive maintenance besides the 31 items on the list, particularly on small general aviation aircraft. So that kind of expanded the scope of what aircraft owners were allowed to do on their own aircraft without the involvement of an A&P mechanic. But what if an aircraft owner wants to do something that goes above and beyond preventive maintenance, say a repair, an alteration, replacing a component, inspect and replace as necessary, that sort of thing, that goes beyond the scope of preventive maintenance that aircraft owners are allowed to do on their own recognizance? Or what if an aspiring aircraft mechanic who doesn't have an A&P rating but wants to become an A&P, wants to apprentice at a maintenance shop, for example, to gain the 30 months of practical experience that the FAA requires before a person is allowed to take the test to become an A&P. You have to have 30 months of experience before you can even take the test. And so typically, mechanic wannabes will serve as apprentices at maintenance shops to gain that experience. The alternative is they can go through a Part 147 school. But frequently, even in Part 147 schools, part of the curriculum will be to apprentice at a maintenance shop. So 43.3 addresses that issue also. That is the ability of an uncertificated person, uncertificated mechanic, to do maintenance on a certificated aircraft. And it discusses that in subparagraph D of 43.3. And here's exactly what that subparagraph says. And the words here are important, so because we're going to be discussing them at some length. But literally, here's what that subparagraph says. It says, a person working under the supervision of the holder of a mechanic or repairman certificate may perform the maintenance, preventive maintenance, and alterations that his supervisor is authorized to perform if the supervisor personally observes the work being done to the extent necessary to ensure that it is being done properly, and if the supervisor is readily available in person for consultation. However, this paragraph does not authorize the performance of any inspection required by Part 91 or Part 125 of this chapter, or any inspection performed after a major repair or a major alteration. Now, that's obviously how the lawyers wrote it, but just in a nutshell, what all that is saying is that a person working under A&P supervision may do anything that his supervisor is allowed to do other than inspections, provided the supervisor meets two specific conditions. First of all, he personally observes the work to the extent necessary to ensure that it's being done properly. And second, that he's readily available in person for consultation. So that's what the regulation says. Now, just to discuss what that means, how much proactive supervision does the supervisor have to do? Well, the wording of the reg says he has to personally observe the work being done to the extent necessary to ensure that it's being done properly. And the way we've always interpreted that phrase, to the extent necessary, is that the supervising A&P has pretty broad discretion and latitude to determine exactly how much supervision is required. In many cases, the supervision consists simply of saying, call me when you're done so I can inspect your work. Sometimes that's not enough, because sometimes some critical parts of the work get covered up, say when the airplane is closed. And so it may, in some cases, be necessary to inspect the work before it's done, or to get involved in it at certain critical phases. So there are cases where instead of saying, call me when you're done so I can inspect your work, it's call me when you get to such and such a point so I can watch and help if necessary. I mean, for example, if the work involved was installing a cylinder, the most critical phase of installing the cylinder is making sure that all of the hold down nuts and the through bolt nuts are torqued properly. And once the work is done, it's pretty hard to tell whether they were torqued properly or not. So the supervisor might want to watch that part of the operation to make sure that the fasteners are properly lubricated before the torquing is done, and that the torque wrench is set correctly and all of that stuff, because that's very critical. So it's kind of highly variable how much supervision is really required to ensure that the work is done properly. But an awful lot of the time, it's just, well, go ahead and do it and call me when you're done so I can kind of inspect your work and make sure it was done properly. Now, keep in mind that the reason this works, giving the supervisor a lot of latitude to decide how much supervision is required, is because the supervisor has very powerful incentive to provide enough supervision. And that powerful incentive is the fact that it's the supervisor who is going to be signing off the work, is going to be signing the maintenance record entry, attesting that the work was performed in a satisfactory fashion, and approving the aircraft return to service. 43.3 talks about who is allowed to perform maintenance, but it doesn't talk about who's allowed to approve maintenance. That's a different reg. That's 43.5. And although uncertificated people are allowed to perform maintenance under supervision, under 43.3D, there's no provision for uncertificated people to approve maintenance. That has to be done by the certificated mechanic. So the mechanic has a really strong incentive to provide adequate supervision, because he's the one that's going to be signing off the work. And if the work winds up not being done properly and then something bad happens as a result, it's the supervisor that's going to be held responsible, both in terms of possible FAA certificate action or possible civil liability for negligence. It's the supervisor who's on the hook for the quality of the work, even if it's being performed by an uncertificated person under his supervision. So that we've talked about the proactive responsibility of the supervisor to personally observe the work to the extent necessary to ensure that it's being done properly. But there's also a reactive requirement, which says that the supervisor must be readily available for consultation, to answer any questions that the apprentice mechanic or the supervised person might have, or to help out if that unsupervised or uncertificated person gets stuck somewhere and needs help. The supervisor has to be readily available in person to respond to requests like that. Now, of course, not every request for help, for consultation, requires the personal appearance by the supervisor. Frequently, such requests can be handled in a phone call or a text message, but there are times when the consultation requires that the supervisor actually be physically present to either look at something or to help out with something that has the supervised person is having a problem with, gets stuck with, or whatever. Now, this rule that I just read to you and explained to you and so on is an old rule. It basically hasn't changed for 60 years. and it's actually older than that. It dates back to the old CAR3 rules that preceded the FARs. And the rule seems pretty straightforward and logical and reasonable, and everybody sort of has been comfortable with it for all these years. There's this rule about supervised maintenance and what the responsibility of the supervisor is and so on. And, almost every A&P has been in a position at one point or another of supervising and signing off work performed by a non-A&P, whether it's an apprentice in a shop or whether it's an aircraft owner who is maintenance involved and wants to do work under supervision that goes beyond his preventive maintenance authority. And most of us, most A&Ps, have had a pretty clear understanding of exactly what these provisions of 43.3D require of us as supervisors. Well, at least we thought we had a pretty good understanding until the FAA threw us a curveball quite recently, and that's where the story starts to get interesting. And it has to do with something that we have come to call the Moss interpretation. Because Mr. Moss started the stone rolling down the. Anyway, this all started about 2.5 years ago, July 8th, 2022. The manager of the Little Rock FSDO, a fellow by the name of Jonathan Moss, sent a request to the Regulation Law Division of the FAA at FAA headquarters, a group called AGC 200, which is the group of lawyers at the FAA who are responsible for writing and maintaining and interpreting the regulations. And Mr. Moss sent a request to this group of lawyers at the FAA, regulation lawyers, asking for a legal interpretation of 43.3D, and he had a specific question about it. And Moss's question was this: he said, in the context of this rule 43.3, does the phrase "readily available in person for consultation" mean that the supervisor must be physically present at the work site, or can the consultation be done remotely using Zoom, FaceTime, live feed TV, digital photographs, downloadable video, or other electronic means? And basically what Moss was asking, and it was actually a pretty good question, was exactly what does in person mean in the 21st century, where we have all of these incredible knowledge projecting technologies like the one that I'm using right now to talk to you. This is a 60-year-old rule that was written back when none of this technology existed, and now we every human being on the face of the earth has a supercomputer with a high-resolution camera connected to the internet in his pocket. I mean, it's just a whole different world that we live in. And all of us have sort of been puzzling over what in person means in this context of this regulation for a long time, but we've all sort of been a little afraid to raise the question with the FAA because we were afraid maybe we wouldn't like the answer we got. So we were happy to leave it sort of ambiguous. But anyway, Mr. Moss asked the question back in July of 2022. And the bureaucratic wheels turn slowly, apparently, especially in this regulation law division of the FAA. And so it actually took the FAA lawyers more than 2 years, 26 months, to respond to Mr. Moss's question. But they ultimately did. And in September 3rd, last September 3rd, 2024, the AGC 200, this regulation law division, sent a memorandum of interpretation to Mr. Moss. And this memorandum was sent to Mr. Moss, but it was, like all legal interpretations, was also published on the FAA website in a database of interpretations. And And the interpretation stated unequivocally that the phrase in person explicitly requires personal presence. And it went on to say that virtual presence through live video feed or other technological means cannot replace the physical presence of a supervising mechanic. Now, I think most A&Ps would agree that when an apprentice mechanic asks his supervising A&P for help, the supervisor's physical presence is sometimes essential. It really depends on what the consultation is. Other times, a phone call or text message is adequate, but there are times that the supervisor actually has to go hands-on to either look at something or help with something. And not all apprentice requests for consultation require physical presence, but some certainly do. So the requirement of 43.3D that the supervisor be readily available to show up in person seems like a pretty reasonable requirement. We've always felt that it was pretty reasonable. And so, if the Moss interpretation ended there, we wouldn't have really had a big problem with it. But unfortunately, it didn't stop there. It went on and said some things that were pretty unfortunate. And in fact, it went on to say some things which I'll describe to you that every A&P that I've discussed this with has found completely unreasonable and unacceptable. For one thing, if you look at the very end, the Moss interpretation is a 3-page memo. If you look at the very end of the Moss interpretation, pretty much the last sentence, it says, and I'm quoting now, "For these reasons, the Office of Chief Counsel finds that 14 CFR 43.3D does not allow for remote supervision of maintenance." Now, that didn't seem reasonable because, although we all agree that personal presence of the supervisor is sometimes required, most of the time it's not required, and most of the issues can be resolved, using a phone call or text message or a FaceTime call or something like that. And this wording is pretty much a total ban on doing anything other than in person. The regulation as it's written talks about that the supervisor has to personally observe the work to the extent necessary to ensure that it's being done properly, and it leaves up to the supervisor to determine what the extent necessary is. But now it seems like the FAA is saying, no, we're going to tell you what the extent necessary is. You can't decide that anymore. Furthermore, this kind of total ban on using any sort of electronic means, it doesn't seem reasonable because, a lot of the time, the best way to determine if work is being done properly is by taking a high resolution photo of it or using a borescope to look at it or, that sort of thing. We do that all the time. And to say, physical presence is the only way that you can supervise just doesn't seem reasonable. I mean, sometimes the old fashioned, look at it with a flashlight and a mirror and an eyeball is the best way to do it, but a lot of the time it's not the best way to do it. And there doesn't seem to be any reason to say that, that the only way to determine whether work is done properly is with photons and not electrons. I guess seems very arbitrary. So, we all kind of feel that it's very important to preserve the meaning of the regulation as it's written. That says that the supervising mechanic should have the discretion to determine what he needs to do in terms of supervision to be satisfied that the work is being done properly, and to what degree his physical presence is needed. Again, he's the guy who's signing off the work at the end of the day. He's responsible for the work being done properly, and if something goes wrong, he's the one that's going to be on the hook for it. So the Moss interpretation's blanket ban on doing any remote supervision seems to take the discretion away from the supervising mechanic. And that really kind of seems ridiculous, because in today's world where we have robotic surgery that is routinely performed remotely from the operating room, where war is being waged with remotely piloted vehicles that are half a world away, and the FAA is increasingly exercising its own oversight tasks remotely. A lot of repair station owners have been reporting to me that their most recent inspections have all been done by Zoom, that the FAA inspector never actually shows up. It's all done remotely. So, given that that's the way the world has moved pretty dramatically, it seems unfortunately conservative and really quite regressive for the FAA to be saying that the only way an A&P can supervise the work of an apprentice is to be physically present. That seems awfully 20th century somehow, and just doesn't seem to comport with the way things are being done nowadays. It's one thing to say that the supervisor needs to be readily available in case physical presence is needed, but readily available could be I'll be there after lunch, or maybe I'll be there first thing in the morning or something. And it's quite a different thing to say that the supervisor's physical presence is always required, and that just doesn't seem reasonable. But that's not the worst of it. The Moss interpretation gets even worse, because right smack in the middle of page 2, there's the following wonderful pair of sentences. It says, this is quoting again from the Moss interpretation memo, the phrase readily available in person for consultation contemplates a physical hands-on approach to supervision. The certificated mechanic must be available not just to answer questions, but to notice mistakes and take over if necessary. Now, that interpretation seems to be reading stuff into this regulation that isn't there in the way the regulation is worded, isn't the way anybody has been interpreting this regulation for the past 60 years. Nothing in the plain language of the regulation, which the language of the regulation seems very reasonable, but nothing in there suggests such an omnipresent and interventionist approach to supervision. But those two sentences appear to completely eviscerate the supervisor's discretion to determine the extent of supervision necessary to ensure that the work is performed properly. And it seems to basically say that the supervisor has to be joined at the hip physically with the person being supervised, looking over his shoulder, breathing down his neck, and ready to take over at the first sign of a misstep. I was talking to my colleague Paul New about this, and he said, does that mean that if I'm supervising work and I have to go to the bathroom, I have to tell the trainee, stop, don't do anything until I get back? It's sort of taking it to the absurd, but that seems to be what the interpretation is saying, is that constant physical presence is necessary, and that the supervisor has to be spring-loaded to take over at the first sign of the person being supervised is making an error. So the FAA seems to be saying that it's not sufficient for the supervisor to ensure that the work has been done properly, that any mistakes are corrected before the aircraft is approved for return to service, which is what we always assumed the standard was. But now, based on what it said in the Moss interpretation, the supervisor is being required to be continually present and perform continuous surveillance and intervene if necessary to make sure no mistakes are made. And that just seems to be a completely unreasonable standard. First of all, how is an apprentice supposed to learn anything if he's not allowed to make mistakes? Because everybody learns mostly from the mistakes they make. And A&P make mistakes all the time. It's not a crime to make a mistake. It's a crime to not correct the mistake before the aircraft is signed off to be returned to service. But to say you can't make mistakes, that just doesn't seem to be a reasonable standard. And I can't believe that what the Moss interpretation is saying is what the original authors of this reg, who wrote it 60 or 70 years ago, intended. Obviously, back when they wrote that reg, they couldn't have possibly anticipated that we would all be carrying high-resolution cameras and be connected to the internet and have all of the knowledge projecting technologies that we have today. But the basic intent of the reg is clear, and it clearly gives the supervisor a lot of discretion as to exactly how much supervision is required. And the Moss interpretation seems to be taking all that discretion away, which all of the A&Ps I've talked to have found pretty unacceptable. So at any rate, the question is it sufficient for the supervisor to ensure that the work is done properly before the aircraft is approved for return to service, which is what we think it should mean? Or does he have to monitor the work from start to finish to make sure that it's done properly at every step of the way and that no mistakes are made, which seems like a very, very different standard and one that's pretty unreasonable. Now, if this Moss interpretation, if it's allowed to stand, it has some pretty serious consequences, we think, and not good ones. Now, I have to be honest with you. I've talked to a lot of people about this, and not everyone I've spoken to disagrees with the Moss interpretation the way I obviously do, and the way all the mechanics I've talked to are very adamant that that interpretation is not an acceptable one. I've talked to some aircraft owners who have said basically, we don't think supervised maintenance should be allowed at all. The quote, one owner is, I don't want anyone but a licensed A&P swinging wrenches on my airplane. And in fact, some aircraft owners are very surprised that it's legal for a non-certified mechanic to work on a certified airplane. But of course, it happens all the time, and pretty much every shop, has trainees, people who are working on their A&P but don't have it yet. I've also heard from a couple of FSDO inspectors who were licking their chops and just couldn't wait to start violating mechanics based on this new understanding of what supervision means, because pretty much nobody that supervises maintenance supervises it the way that the Moss interpretation says it needs to be supervised. But if the Moss interpretation is allowed to stand, then the consequences could be pretty severe. First of all, almost every maintenance shop, whether it's a GA shop or an airline operation, I even have a good friend who works at Boeing who says, hell, most of the people who work on the Boeing aircraft at the factory aren't licensed. They're working under supervision. But virtually every shop employs mechanic apprentices who are working to become A&Ps, but don't yet have the 30 months of practical experience required qualify to be A&Ps. I mean, how are people supposed to get that experience? You get it, by apprenticing. And under Moss, any mechanic apprentice would require full-time supervision by an A&P who would have to continuously watch every phase of the work and be spring-loaded to take over at any moment. And the supervisor would be precluded from using any electronic means to perform the surveillance. He would have to be literally looking over the guy's shoulder. And, that kind of continuous in-person surveillance is simply economically unsustainable. No shop could afford to take on apprentices if they literally had to dedicate an A&P full-time to supervising the apprentice. And so, basically, if Moss stands, the whole notion of apprenticing to earn your A&P would I think come to an end. Also, supervising aircraft owners who want to do owner-assisted annuals or want to do other maintenance tasks under supervision. Again, would no longer be economically feasible. Mechanics, couldn't afford to do an owner-assisted annual if the mechanic had to spend full time supervising the owner and couldn't do his own work. So there wouldn't be any more, okay, go ahead and do that and call me when you're done so I can inspect your work, which is basically the way it mostly works now, or call me when you're ready to perform some phase of the task so I can watch you. None of that would be allowed anymore. The surveillance would have to be continuous. So we think that the Moss interpretation, if it is allowed to stand, would make owner performed maintenance under supervision a thing of the past. It is nobody could afford to do it. And given the acute shortage of A&Ps that we presently have, throughout the industry, but in the GA part of the industry in particular, it seems like it would be particularly unfortunate to put an end of the ability of shops to employ mechanic trainees who want to become A&Ps, and it would be very unfortunate to put an end to use owner-assisted annuals and other owner-performed maintenance performed under supervision. Now, I found out about this, about 2 weeks after the Moss interpretation was published. I got called by a friend of mine who runs a Part 145 repair station in the Central Valley of California. And he said, Mike, have you seen this? This is awful, And I said, seen what? And he sent me a copy of the Moss memo, and I read through it. And then I read through it again. And the more I read through it, the more upset I got. And I said, we got to do something about this. We can't just allow this to become the law of the land. This is really, really bad. So in late September 2024, and the interpretation, was issued at the very beginning of September, I wound up drafting an 8-page letter to the Regulation Law Division of the FAA and made a formal request for expeditious reconsideration of the Moss interpretation. And I asked them to reconsider it and hopefully issue a superseding interpretation that restored the supervisor's discretion to determine the extent of supervision necessary to ensure that the work is being done properly, and to rescind the total ban on using electronic means to satisfy the requirement to personally observe the work performed. And so in short, the letter asked the FAA to restore the original plain language meaning of 43.3D as it had almost universally been understood for the past 60 years before this Moss interpretation came out. I talked to a whole bunch of people about this before I sent the letter, and I talked to shop owners. I talked to people who were instructors at Part 147 A&P schools, accountable managers at repair stations. Everybody I talked to said, I want to co-sign your letter. So the letter wound up going out with 10 co-signers, all A&PIAs who were either shop owners, directors of maintenance, instructors at Part 147 schools, and so on. So there was my signature and 10 other signatures on this letter, and we sent it off to the head of AGC 200. I then started making phone calls to people that I knew at the various alphabet groups, AOPA. I got particularly good attention from Pete Bunce, who was the head of GAMA, the General Aviation Maintenance, the General Aviation Manufacturers Association. I also talked to Sarah McLeod, who runs the Aeronautical Repair Station Association. That's the alphabet group that represents shops. And brought this to I said, did you see this? And they all got equally upset, and they started calling their friends at other alphabet groups. And so a couple of weeks later, on October 10th, a second letter requesting reconsideration of the Moss interpretation was sent to AGC 200. This one was signed by the most amazing consortium of industry alphabet groups I've ever seen. I mean, there were every alphabet group that I knew about, and a whole bunch that I didn't even know existed, signed on to this letter asking the FAA to reconsider this interpretation because everybody found it so objectionable. And Pete Bunce of GAMA was apparently on a first name basis with the chief counsel himself, Mark Nichols, and so he said, "Hey, Mark, you really need to take a look at this. This is really bad." And I remember I was also talking to my colleague Jeff Simon, who was on a first name basis with Congressman Sam Graves, who heads the Transportation Committee in Congress, and he got Sam interested in this issue. So we put pretty much a full court press on the FAA about this. It was amazing how quickly it came together. And we got their attention on October 15th, which is about 6 weeks after the Moss interpretation first came out. We got a letter from AGC 200 that stated the following. It said, "This letter is to inform you that the FAA is issuing a stay of the legal interpretation of 14 CFR 43.3D dated September 3rd, which is the Moss interpretation, while the agency reviews its policies and regulatory options." It says this stay does not represent a conclusion on the contents of that interpretation, and the stay will be effective until such time as the agency issues new or supplemental guidance. There has been no new or supplemental guidance since that time. We made a formal request of the FAA to convene a meeting of industry representatives to discuss these issues before the FAA comes out with anything further on interpreting 43.3D. We've not yet gotten any acknowledgement that the FAA is willing to have such a meeting, but as you know, there's a whole bunch of turnover in the FAA right now, including the administrator in the wake of the election, and so we're not sure if there's going to be any follow-up on this, whether it's going to quietly die or whatever. But at any rate, at least for now, 43.3D is back to meaning what we thought it always meant, that supervisors will supervise to the extent that they feel necessary to ensure the work is being done properly, and that they have to be readily available in person for consultation, but not omnipresent in person for consultation. And I think that's a great thing. So you actually can fight City Hall. And it was kind of fun going through this, and basically convincing the FAA that what they came out with wasn't good, and to their credit, they reconsidered it, and at least for now, taken it back. So, Tim, that's all I have, but I'd be glad to have a discussion about any of this if anybody has anything interesting to say or ask or whatever.
All right, Mike. A lot of people kind of commented, kind of agreeing with all of your commentary there in terms of how bad it is. Not a lot of questions. I got a comment here from Mark. He says, this is similar to attending surgeons and their residents, talking about apprenticeship.
Mm-hmm. Probably is, yeah.
Mm-hmm. So
that wasn't Mark Nichols, was it?
No.
Okay.
Najar was wondering, how does this rule fit into Part 145 repair station environment?
Well, the rule is constantly used by Part 145 repair stations, because Part 145 repair stations, probably more than anybody, employs uncertificated apprentice mechanics that work under supervision. So this applies to everybody. Again, the important thing to understand is that the rules allow uncertificated people to work on certificated airplanes under supervision, but the rules do not allow the uncertificated persons to approve the work. The approval of the work is always done by the certificated mechanic. Or in the case of a repair station, the approval could be by the repair station as a certificate holder itself. But it's always the supervisor that's on the hook for the quality of the work, not the person who's performing the work, but the person who's approving the work is the one who's on the hook for it.
A few people are wondering, like Michael's question here, what prompted the original question from Mr. Moss?
Well, we don't know that. We've speculated about that since it, came from the head of the Little Rock FSDO. My best guess is that it was prompted by some enforcement action that the Little Rock FSDO was taking against somebody. And there was some debate about, whether some work being done by an uncertificated individual was properly supervised or not. And so my guess is that that's the kind of thing that might have prompted the question, but there isn't anything written anywhere that indicates what Mr. Moss's motivation was. The memo of interpretation from the FAA lawyers is what is published, but the original letter from Mr. Moss to the FAA was not disclosed. So we never got to see what Mr. Moss actually wrote that prompted all of this. We know it took 26 months for them to respond, but we don't really know what he originally said in 2022.
Mm-hmm. Several people are thanking you for your efforts in this, heading off this issue. Good job, Mike.
Well, thank you. I kind of enjoy jousting with the FAA on stuff like this, and almost all of my jousting in the past has had to do with airworthiness directives. This one was a little bit different. I don't think I've ever gotten into a situation where I was debating with the FAA about a regulatory interpretation, but at any rate, it is kind of fun to do, and I think it's an important lesson that that it's worth pushing back if the FAA comes out with something that you disagree with. It's definitely worth pushing back. I've pushed back on a lot of ADs. I would say our batting average in getting the unreasonable ADs overturned or modified is maybe a 50% batting average. I mean, sometimes we succeed, sometimes we fail, but it's always worth doing. And this was certainly worth doing.
James is wondering, would this have affected the light sport repairman certificate?
I don't think so. I don't think that 43.3 is applicable to anything but certificated aircraft.
All right. Yeah. Brian just says, thank you for speaking up for all of us. I think
You're
everyone
welcome,
in attendance here is probably in agreement. It seemed like that Moss interpretation was quite a stretch, and everybody's happy you fought back on that, led the charge, helped lead the charge.
You know, for years, I've had a lot of dealings with AGC 200 over the years, and for years they had a wonderful lawyer in that group, a fellow by the name of Edmund Averman. He went by Skip Averman. I actually took him to lunch one day in Washington, although that's probably not the right phraseology, because he didn't allow me to take him to lunch. That's apparently a violation. We had to go Dutch, but anyway, I had lunch with him one day in the cafeteria at 800 Independence Avenue. And Skip was one of these guys that you could always rely on to interpret the regulations in a reasonable way, and often in a way that was, very favorable to aircraft owners and mechanics and so on. And he really understood the way the world works in the field. And I knew that the day was going to come that Skip was going to retire, and he finally did retire a couple of years ago. And his shoes were obviously very hard to fill. I seriously doubt that this interpretation would have ever come out if Skip was still working at AGC 200. But unfortunately, people don't last in those jobs forever, and he reached retirement age and left the group. So it's a big loss, I think.
So just to be clear on this, so everyone understands, this legal interpretation is not valid right now. It got set aside, stayed, so it's like it never happened, right?
Yes, they basically took it back and said, we want to think about this some more.
Yep. So right now, really nothing has changed from before that thing even was published in terms of how you interpret supervising.
Right. They issued the interpretation, then they stayed it, which basically meant that they took it back. And we have made a request, and when I say we, that it's really this consortium of alphabet groups that made a request that before the FAA come out with any subsequent interpretations of this reg, that they hold a meeting, which we were happy to do via electronic means if necessary, so that they could hear directly the concerns of industry about this before they came out with any further interpretations of 43.3. But for now, the Moss interpretation has been taken back, and it's officially under indefinite advisement.
Mm-hmm.
And if the FAA actually wants to issue a substitute interpretation as opposed to doing nothing, we would really like them to hold a meeting with us first so that we can discuss our concerns. But it's sort of the next move is really up to the FAA at this point.
Mm-hmm. Well, Mike, let's wrap it up here. Looks like we had about 500 people logged in here. Why don't you take a moment and share closing thoughts?
Okay, happy to do that. One of my closing thoughts was that I have never seen the industry come together on something so quickly as what happened in this case. Literally in 2 weeks, every single alphabet group representing every single phase of the industry, from airlines to repair stations to aircraft owners and pilots, every single group came together in opposition to this thing, which was, I found, extremely impressive. Any rate, just in closing, if you're not on my email list, I send out a monthly newsletter and other stuff, including I sent out a bunch of alerts about this Moss interpretation as it was coming down. But if you're not on my email list, the easiest way to do that is to text the word SAVVY, SAVVY, to 33777, and it'll put you on our mailing list. Or you can also go to the savvyaviation.com website and add yourself to the list that way. My books are all available where fine aviation books are sold. The EAA bookstore, Aircraft Spruce, Amazon, all of the books are available in audiobook form also, and those are all available on Audible. The podcast that I do with Paul New and Colleen Sterling, which we now do twice a month, on the 1st and 15th of the month, is available. It's called Ask the A&Ps, and you can get it any place you get podcasts, Spotify, Apple Podcasts, et cetera, et cetera. It's pretty widely distributed, and we try to answer thorny maintenance questions, and we kind of have a lot of fun doing it. And there's also a video version of the podcast that is available on YouTube. And finally, the next 3 webinars that are all first Wednesday of the month webinars. February webinar is called Data Driven Diagnosis, and it basically talks about a bunch of specific real life cases where we used engine monitor data to diagnose, to provide pinpoint diagnosis of engine problems, and kind of show you how we go about that. It's engine monitor data is incredibly valuable for doing diagnosis, and yet it's not used enough. Most A&Ps don't really appreciate the diagnostic value of that data. So I'm going to be talking about that. The March webinar, where the title is "Worth the Squeeze," that's really the question is all of the extra rigmarole that certificated aircraft owners have to go through compared with experimentals, does that really achieve a significant increased level of safety? And I go through some of the statistics on accident rates among certificated aircraft versus experimental aircraft, and there really are some kind of interesting conclusions there. And the answer is that it's not clear that we get a whole lot of extra safety value from all of the stuff we have to go through as owners of certificated aircraft, and having to install approved parts and have IA sign off annuals and all of this stuff that we have to go through. So that's what the March webinar is about. And the April webinar is called Security Violation, and it's a little departure because it's not really about maintenance, but it has to do with something that happened to me over Christmas when I took my big adventure, my 310, flew it to Florida and back. I got slightly crosswise with TSA on something, and wound up learning a whole lot about TSA and general aviation, and So it's an interesting story, and I'll be telling it during the April webinar. And that's all I've got, Tim. Happy New Year, everybody.
Hey, Happy New Year to you, Mike, and to everybody else. Thank you so much for tuning in. Have a great evening, everyone. See you next time.
Good night, everybody.